everyone. My name is Gaston, and I'm here with this week's Markman Minute, which you can find at mimesiswebtv.com. Here to talk to you today about a ongoing situation involving efforts by a hedge fund owner by the name of Kyle Bass, working together with a person who's been specializing in patent litigation for over a decade, Erich Spangenberg, who have started a program of raising capital to attack drug companies, and in particular to take patents that they feel are weak and that the drug companies are using to protect their profits from generic competition, and challenging those patents in the patent office. And in order to understand the strategy, it makes sense to understand a little bit more about what procedure they're using. And what they're using is something called the Inter Partes Review, which was established as a result of the passage of the America Invents Act, which was a major overhaul of the patent laws that happened a few years ago. And the Inter Partes Review was originally contemplated as a mechanism for allowing companies that were in litigation or had or believed that they might be in litigation to challenge patents in the patent office at a much reduced cost than if they were going through a district court proceeding. And an inter partes review is exactly that. You're asking the patent office to take another look at patents that they've already issued. And there's a number of advantages to an inter partes review for a challenger as opposed to the district court. One is, of course, it's cheaper. Second, the inter partes reviews follow a more set schedule. So from the time you file your petition, you usually have a decision by the patent office no later than 6 months as to whether or not your review will be accepted, or in the parlance of the industry, instituted. And once a patent review is instituted, then the patent office sets a 12-month trial schedule. So from the beginning of the process to the end, you're looking at no more than 18 months before you get a final decision as to whether or not a patent is going to be remain valid or going to be tossed out. The early adopters of inter partes reviews tended to be technology companies that like Google and Apple, that are frequently hit with what they consider patent troll lawsuits, or lawsuits from entities that purchase patents or somehow otherwise acquire patents and sue the bigger companies as non-practicing entities, hoping to get reasonable royal damages or a settlement. And the Inter Partes Review was adopted by companies like Google and others in the technology industries as a way of defeating these challenges more quickly than going through the district court process. Quite frequently, these situations happen in parallel. So a case will be filed against a company, they will file the Inter Partes Review, and they will ask for a stay of the district court litigation. So that helps also keep the costs down, and allow the defendant to take a little bit of the initiative back, and cause people to cause the patent owner to defend the validity of the patent before you get into some of the other issues in the case. What's happened, though, in terms of what Bass and Spangenberg are doing, is they're using the model in a slightly different way. And what they've come out publicly and said is that they're going to raise money for a fund, and they're going to identify patents that they think are weak, and they're going to use inter partes reviews as a way of getting the patent office to reevaluate these patents. Part of the way they hope to profit from this endeavor is by shorting the stock of those companies. And we have seen situations like their first publicly filed IPR, which they filed against a biotechnology company called Accorda, where the stock actually did fall in a material way upon the news that Bass and company were challenging the patents. Since then, they filed IPRs against 6 or 7 other targets, and we're starting to see that the market reaction to those filings has been a little bit more muted. But that hasn't discouraged them from pursuing this strategy, which we believe is a long-term strategy, to demonstrate that drug companies are overvalued, they charge too much for their drugs, and they use their patents as a way to protect their monopolistic revenues longer than they should be allowed to. And that the inter partes review process is a way of clearing out the bad patents and fostering generic competition quicker. And if it so happens that the stock value of the company goes down as a result, that goes to the benefit of Bass and his investors. So it's a very interesting development. There's a lot of talk. Bass has been very active over the last few weeks, and we think that this is an ongoing situation that needs to be monitored very closely with a lot of interest for investors. That's this week's Markman Minute. My name is Gaston. You can find our content on MimesisWebTV.com. See you next time.